Welcome to meeting number 13 of the House of Commons Standing Committee on National Defence. Pursuant to the motion adopted on October 23, 2025, the committee is meeting to resume its consideration of Bill C-11, an act to amend the National Defence Act and other acts. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members are attending in person and some remotely using the Zoom application. Before we continue, I ask participants to consult the guidelines on the table to help prevent audio and feedback incidences and to protect the health of the interpreters. I would remind also the witnesses and to members to please wait until I recognize you by name before speaking, and for those participating via video conferencing to click on the microphone icon to activate your mic, and please mute yourself when you're not speaking. And for those on Zoom, at the bottom of your screen you can select the appropriate channel for interpretation, either floor, English, or French. For those in the room, please use the earpiece and select the desired channel. And again, all comments should be addressed through the chair. If you wish to speak, please raise your hand. For members on Zoom, please use the hand raise function, and the clerk and I will manage a speaking order as best we can. And we appreciate your patience in that issue. Before we begin with our witnesses, I'd like to note, and I think you're all aware, that we are discussing some, at times, uncomfortable experiences related to sexual misconduct. This may trigger sensitivities and distress, so it's important to recognize that these are difficult discussions, and I'm sure we'll all be compassionate in our conversations and questions. And if you feel you need some help, please advise the clerk. I'd now like to introduce our witnesses.
Point of order.
You may.
Just before you introduce our witnesses, we have 3 witnesses up for 1 hour, and then 1 witness in camera in the second hour. I think in fairness to the 3 witnesses that are here in public, that it'd be good if we could listen to them and meet with them for 1.5 hours, and then reserve half an hour for in camera.
With agreement of the members around the committee, it was our intent to extend the period of time by which the 3 members were speaking, and to then provide some adequate time for the in-camera component, which I was proceeding to do. Okay. So if that's okay with everyone, we'll provide possibly an additional 20 minutes or so, because then I have to accommodate the transfer into it.
Perfect.
Okay? All right, so witnesses before us is Dr. Karen Breek, a retired major and medical doctor. We have Afton David, senior legal counsel, and Bruce McGregor, retired colonel and former director of military prosecutions by video conferencing. And now I'd like to invite Dr. Breek to make your opening statement. You have up to 5 minutes.
Thank you for inviting me. My name is Dr. Karen Breek. I'm a retired Canadian Armed Forces medical officer. I've testified before this committee and at Veterans Affairs, Status of Women, and the Senate on issues related to sexual misconduct and women veterans' health. Please consider my past testimonies alongside today's. As the committee already has my October 23rd Hill Times letter, I would like to augment it with 9 comments and 3 recommendations, focused only on the bill's proposed mandatory civilian referral of all sexual offenses. My hope today is to keep our discussions focused on the agency, equity, and well-being of the humans impacted by these workplace-related events. First, the military of 2025 is not the military of 2015. Many problems identified in the Deschamps and Arbor report no longer exist. Today, the chain of command has extensive awareness and training. The Sexual Misconduct Support and Resource Center is fully operational. Victims' rights legislation is in force. Independent legal and victim supports exist. And duty to report has been removed. So what evidence still shows Recommendation 5 remains the best way forward? 2, the bill removes choice. Mandating transfer of all 28 listed sexual offense charges, regardless of severity, is not people-centered. It will reduce reporting. Many would prefer a quick internal military resolution, especially for low-risk cases. I've spoken to many people who fear being labeled disloyal or overreacting if they were to involve civilian police, particularly for the lower-risk sexual assault cases, things like an unwanted pat on someone's fully clothed buttocks. Third, research is clear that resolving the lowest risk nonviolent adult cases, for another example, an unwanted kiss to the cheek, in a timely, efficient manner is essential to preventing escalations in unwanted workplace behaviors. Keeping the option for these type of low-risk cases to remain within the military discipline system can benefit everybody. Fourth, accused members receive free legal counsel within the military system, but not if charged in the civilian system. This inequity risks unequal access to justice for the accused through forced self-representation or significant personal debt. 5. Potential complainants worry about an already strained civilian police and court system. Access to federal funding, if required, might help police forces be more willing to accept and complete complex military cases. 6. The bill relies too heavily on legal lenses. It is missing survivor, Indigenous justice, gender-based violence, public health, occupational health, and safety perspectives. The 75 recommendations from Schedule N and O of the Sexual Misconduct Class Action should also have informed this bill. Please add both reports to your considerations. 7. I am saddened by the absence of NDP voices on this committee. They historically have been strong allies on this file. Please include Ms. Lindsay Matheson's remarks of September 19th, 2024 on Bill C-66 in your considerations. 8. There is no evaluation framework. Without one, how can we measure justice or culture change? I encourage that all government-collected data since 2021 on civilian referrals be included in your review on how to best develop a robust evaluation framework moving forward. 9. The military is set up to train how we fight. And if the military justice system is good enough for deployments, it should remain, at least in part, an option in Canada. In closing, military justice does require reform, but reforms must reflect the realities and the lived experiences of 2025, not 2015. Together, we can make Bill C-11 a landmark bill. I recommend the bill advance, but with the following changes. 1. Section 70, paragraph D, exclude low-risk, non-violent adult cases so as to allow the complainant choice for their jurisdictional management. 2. Add federal funding for defense counsel and for complex police or court processes. 3. Add mandatory data collection and a 2-year review of outcomes and satisfactions for complainants and accused before making these changes permanent. Thank you. I welcome your questions.
Thank you. Okay, we have Karen. Ms. David, you now have opportunity for making your opening statement. You have up to 5 minutes as well.
Thank you, Mr. Chair, and thank you for your time. I come to you today as a lawyer with a keen interest in matters of military justice. My interest stems from my own service as a reservist and from my family's service. I'm a proud military spouse, sister, cousin, and soldier. This means that I am also a woman, a lawyer, and a soldier, and I contend that this provides me with a unique perspective. I have the benefit of appearing at the 3rd iteration of witness committees, or 4th perhaps, for this bill. I also have the benefit of several comprehensive reviews of various aspects of the military justice system. I welcome the bill's efforts to implement important recommendations from independent reviewers, but I urge this committee to treat it as one step in a much broader program of reform required to restore trust, protect victims, safeguard the accused, and change culture across the CAF. Bill C-11 effectively nullifies the Code of Service Discipline's jurisdiction over criminal code sexual offences that occur in Canada, rather than transferring jurisdiction. That decision risks passing responsibility to the civilian system without resolving the systemic causes that produce loss of confidence in military justice in the first place. Culture change and leadership accountability must accompany any legislative change because courts martial are only the apex of a system where most matters are handled by unit-level processes. I will share the key recommendations I make in my written submissions for the benefit of Canadians listening in on this committee. You'll quickly see that I'm not reinventing the wheel. I'm merely reiterating recommendations made by some very intelligent and legally astute Canadians before me. First, make it clear that authority is not being transferred. Instead, the bill removes the military justice system's power to deal with sexual offenses under criminal code that happen in Canada. I further recommend including a sunset clause in this particular amendment. Second, and to echo recommendations made by Madam Justice Arbour, mental health supports must be expanded and made independent of the chain of command for serving members and veterans in order to aid prevention, early intervention, and reduce recidivism. I also strongly recommend this government follow through the commitments they made to explore alternative care for veterans, including research into psychedelic-assisted therapy. CAF leadership needs to be given the tools to guide their subordinates in the right direction. They do not need another 1-800 number. Third, I agree with my colleague witnesses that there should be a limit on the time taken to fill governor and council appointments for key military justice roles. This must be paired with meaningful consequences for prolonged vacancies. 4, I recommend this committee strengthen judicial independence by removing military judges from the application of the Code of Service Discipline. I also recommend expanding military judge eligibility to include serving and former members with at least 10 years service at the bar and bar membership. I also strongly support the creation of a permanent courts martial to reduce ad hoc inefficiencies and independence issues. 5, prohibit commanders and statutory decision makers from imposing administrative measures on accused, thereby effectively adjudicating criminal matters before the courts complete the processes. 6, remember that both victims and accused are entitled to fundamental rights and safeguards. I recommend ensuring access to justice is maintained for accused members by providing defense counsel for service members charged in civilian courts. I further recommend this committee amend the bill to also guarantee the right to counsel in summary hearings. 7, appoint an accused liaison officer akin to a victim liaison officer to coordinate between the accused, the chain of command, and civilian processes. Bill C-11 contains important and constructive reforms, and I appreciate the legislature's and this committee's careful work to implement recommendations from independent reviews. I offer these additional observations with humility. The bill will be most effective only if paired with sustained culture change, timely and accountable appointments, protections for judicial independence, independent mental health supports, and concrete measures to safeguard both the victim and the accused, including access to counsel and fair process for the accused by virtue of our fair and democratic society. I recognize that some recommendations will require time, resources, and careful drafting. I respectfully urge the committee to consider them as efficiencies because legislative and regulatory fixes now will certainly be more cost-effective than relying on litigation to correct gaps later. Thank you for your time.
Thank you, Ms. David. I'll now pass it over to Colonel McGregor. You have 5 minutes. Thank you. You're on mute, sir. You're on mute.
Thank you, Mr. Chair. I appreciate the opportunity to speak to you and to the committee. You have my bio before you, so I won't go over that. I'll get right to my points. The independence of the Director of Military Prosecutions, as Mr. Justice Fish has noted, this is imperative going forward and is in line with the Cawthorn decision of the Supreme Court of Canada, of which I was a part a number of years ago. The appointment for a non-renewable term of 7 years is appropriate and is consistent with the Director of Public Prosecutions of the PPSC. A GIC appointment is an appropriate level for the appointment, but the bill should be amended to ensure that the DMP annual report be tabled before Parliament each year, similar to that of the JAG annual report. This will ensure that the DMP has transparency and unfettered access to illustrate any encroachment on his or her independence from the chain of command, the JAG, or the minister. The disciplinary committee for the DMP has proposed if the DMP is found to have acted inappropriately, the committee should recommend removal, not suspension, nothing else. The DMP is a commanding officer in the Canadian Forces, and if he has acted outside the professional bounds of his or her duties, he cannot do that job and must be removed, not suspended. An acting DMP requires more than 90 days for various reasons, operational, health, etc., so that the power should be given to the minister to grant an extension with written notice to the GIC for any extended period for an acting DMP. The power to give instructions to the DMP by the JAG on individual cases should be transferred to the minister and should be gazetted. The minister's prosecutorial role is confirmed in the Cawthorn case also, which I had a part in. With respect to Justice Arbour's recommendation number 5, the removal of jurisdiction on sexual offenses, I have to note that Justice Arbour's recommendation is not entirely consistent with the previous recommendation of Justices Deschamps and Fish, Deschamps recommendation number 8 and Fish recommendation number 68. Bill C-25 back in 1998 provided jurisdiction to prosecute sexual offenses in the military, but the power to investigate by the military police was already extant. This recommendation takes away the military police power that has existed for decades. Admittedly, the military justice system has flaws with respect to protecting victims and has been slow to move, but it has made significant strides since the Deschamps report, which is much more consistent with the equally flawed criminal justice system. The expectation that victims will be completely satisfied with the criminal justice system is aspirational and not realistic. Many, if not most, allegations of sexual assault within the military are not what we would consider or characterized as rape, but as what may be considered as a lower level of physical violence. By saying this is in no way an attempt to minimize the impact on victims. The criminal justice system is overburdened and fraught with delay and lack of funding, which causes civilian police and prosecutors to triage cases, which will not guarantee military cases going forward, no matter how important the case is to the victims and or to the military discipline. The criminal justice system has a different purpose than the military justice system. The military justice system's purpose, as recognized by the Supreme Court and in the National Defense Act, is to promote discipline, efficiency, and morale of the Canadian forces and to make it more operationally effective. Cases heard in the civilian courts are away from the bases, physically away from the bases or units where the incidents happened, and out of view of the Canadian Forces members that need to hear the evidence and the sentence if applicable, which by having them away, it reduces the goals of discipline and transparency. Cases that do not go ahead in the civilian justice system will likely be dealt with administratively, vice in public, significantly reducing the minister's goal of transparency. The stories of victims will not be heard in the environment where the victims wish to return and to be treated with respect, casting a shadow over his or her return. Taking the choice away from an informed victim is paternalistic and further disenfranchisement of a victim who has already been rendered powerless by the perpetrator. The DMP and their team of prosecutors are more available to victims throughout the process, as can be seen by the DMP's pre- and post-charge policies and by the DMP's personal history of sharing knowledge and training with the SMSRC and victims groups. The SMSRC has been providing significant resources or has been provided significant resources and is a Cadillac support for victims going into the system, both before and in court, which will not be dealt with consistently across all civil courts across the 10 provinces and 3 territories.
Colonel
Of the victim and
McGregor?
yes.
Yeah.
Yes.
We need to wrap it up. Just your time is up. So I'll let you wrap up for a few minutes, a few seconds, I mean.
Okay, thank you. Protection of the victim and the evidence is enhanced where the chain of command has some information vetted by the DMP, and no information will be available to the chain of command if it's from the civil prosecutor or the civil police. Those will be roadblocks to information, which hurts the ability for the chain of command to protect victims while also conducting operations. Those are my comments. Thank you very much, Mr. Chair.
Thank you, Colonel McGregor. All right, we're going to start our first round of questions, and we have up to 6 minutes for each question, starting with Ms. Gallant.
Thank you, Mr. Chairman, and through you to Colonel McGregor. In 2020, the 4 charges against Chief Military Judge Mario Detil had been withdrawn. In Bill C-11, we have Section 11, where it removes the ability for judges to be charged with having committed a service infraction. Do you think that makes the military justice system stronger, or should that indeed be removed from the bill?
Well, I don't want to necessarily comment on the specific case, but they are still a military member. They are the chief military judge is a colonel, and I do feel that if there is a criminal code offense that they have committed, they should be liable to investigation and prosecution if the evidence warrants. With respect to a disciplinary offense, which or a service offense, I would be reticent to say completely that it should be taken away.
As the former director of military prosecutions, how confident will you be in the military justice system once national defense can influence cases done by the JAG?
National defense could be influenced, or the minister?
The minister.
The minister, in the Cawthorn case in 2016, the minister is quite properly placed within a prosecution system. In terms of, in the Cawthorn case, he was properly placed as the person I had to go to in order for us to go ahead with appeals to the Court Martial Appeal Court of Canada or to the Supreme Court of Canada. If the minister is acting out without partisan political purposes, then the minister is quite properly placed within a military justice system. If he or she acts with political or partisan purposes, then that is totally inappropriate.
So, in your opinion, would the Minister of National Defense then have to be a lawyer?
No.
Okay, so as former DMP, what concerns, if any, now that the office term has been extended to 7 years without eligibility for reappointment, you are in line with that?
Yes, I am. It's entirely consistent with the DPP.
Okay, so from your assessment of C-11, what shortcomings could you identify to this committee where the government has overlooked, if any?
Well, like I said in my opening comments, I'm concerned that with the changeover to the minister being able to give specific instructions on an individual case, that should be gazetted. That's not in the bill. And also there's nothing to reference the DMP's annual report being tabled to Parliament through the minister. That is, as far as I'm concerned, mandatory for the DMP to have that ability to make contact now that they will be a GIC appointment with Parliament to say if there has been improper actions or any concerns that they have with the military justice system. And I have a great concern with recommendation number 5 being fully implemented as it is in taking away the jurisdiction for the military justice system to be able to investigate and prosecute crimes of a sexual offense.
Since your retirement as the DMP, would you characterize the state of our military justice system to be in a worse position than when you left?
Well, I'm concerned. I'm very concerned because I'm well aware of the professionalism of the actors within the military justice system, including prosecutors, defense, and the judges. And with the transfer of cases of sexual offenses to the civilian system, they are not getting the attention that they would be getting within our system in the civilian system. It's just that's a fact, and We take it very seriously. Like I said, we have a different purpose than the criminal justice system. Ours is to promote discipline, efficiency, and morale and operational effectiveness. The criminal justice system is to put the evidence before the court and see if this is a criminal offense and then deal with it that way.
So, in your observations, do you think the current senior leadership within the CAF is in a better or worse state than when you retired, from your position when it comes to combating military misconduct?
I wouldn't want to comment on that. I'm certainly not in a position. I haven't followed it nearly as much as I would have while I was in uniform. So I'm really not at liberty to comment on that.
Are there any other parts? Did you just cut me off, Mr. Chairman?
Yeah, you got 2 seconds.
Okay, so after you left the, have you heard of any complaints about the contents of C11 and its inadequacies to reform the military justice system? Are you aware of any?
No, all I have done is followed what your committee is doing, and I've listened to other people's input and followed some of the speeches in Parliament. That's about it, and I've formed my own opinions. But it's also based on my extensive knowledge with the heads of prosecution, the International Association of Prosecutors, my former prosecution role, my former defense role, and my former role as a federal prosecutor, agent, and as a municipal prosecutor. And I've dealt with police for probably about 35 years. So based on all of that, this is where my opinion's coming from.
Thank you, Colonel. Thank you, Ms. Glad. Vivian Lapointe, you have up to 6 minutes, and I'll be counting.
Thank you, Chair. Dr. Breek, regarding the Hill Time op-ed that you mentioned in your opening remarks, you wrote about how women veterans have often been made invisible through gender-blind systems and legacy policies built on the assumption that a soldier is a soldier is a soldier. What helps ensure that women's veterans' experiences and their needs are genuinely seen and understood when institutions are undergoing major reforms like the one proposed in C11?
Thank you for that important question. I'm also acknowledging I'm at NDDN today and not ACFA, so I think therein lies part of what, in my now 35 years of being in this field as well, we constantly see this mother-father separation that consistently tends to cause the slowness in actually moving stuff forward. One of the questions would be, how do women veterans get seen? Well, are we part of the defense team or are we not part of the defense team? It seems like that changes depending on the political wish or needs of the day. If it was recognized that we're part of the defense team, we would be a regular part of these discussions, especially being aware that we are now not in uniform and able to speak in a very different way than we could while we're still in uniform. So I think that's part of the motivation for a lot of us to be at these kind of events, because we know our peers still in uniform do not have that same privilege to speak truth to power. And so by not allowing people like women veterans to regularly be viewed as part of these discussions, we also, again, because the two committees are separate, I know for many years we have said why for certain topics like this that clearly cross boundaries, can we not have, I don't know the right words for it, but a subcommittee that's half NDDN and half ACFA, so we can actually get to the end of some of these instead of doing half the problem at NDDN and then waiting and do half the problem at ACFA and then nothing actually happens until we can actually acknowledge that the problem crosses the two departments, and especially for women. I think a lot of our issues aren't necessarily so focused on what percentage or money we're getting for disabilities. We had injuries related to equipment, and we can fix the equipment. We want it to be better for the women behind us. We want it to be better for the women that are signing up today as daughters and granddaughters, that the system has thought of them and expects them, that they're not the anomaly and that they're not given male equipment and told, suck it up. And then when they have their injuries, be told that those injuries aren't recognized, misdiagnosed, and that they're not going to be considered service-related injuries when we hit Veterans Affairs. And that's still, unfortunately, our state of affairs. So listening to us in part, I, again, would challenge, especially, I'm really excited to see that there's people with such dedication to these topics that have bases, that are part of the bases, that have kids in the military, that have lived experience. This is a very exciting committee group here to me on we can do better. We can do it differently, and we can actually fix some of these problems instead of handing them off to each other. Most veterans I know only come back over and over again because we're trying to make it better for those behind us. So empowering us to have that voice, to be heard as part of the defense team on a more regular basis, to me, would be one of the really easy ways. I'll do a quick, of course, in case anyone isn't aware, there was a 1-year study on the experience of Canadian women veterans at the ACVA committee that got tabled and actually had our celebration in this room. So this is my first time in this room since June 12th, 2024, when all parties signed 42 recommendations of things that we can do. And again, if you look at those recommendations, my count, about 50% of them cannot be done without CAF and D&D. It is a significant overlap. So we need to work together on these issues, would be my short answer.
Also, in your opening comments, you provided some recommendations of changes that you would like to see in C11. And one of those you spoke about adding mandatory data collection. Can you expand on that?
There's a medical phrase that might be appropriate for this time on the surgery was successful, but the patient died. In my lived experience of, again, now over 35 years of watching, for the most part, women doing what they were ordered to do when we still had the duty to report. They had no choice. They were ordered to come forward with certain issues. But by following and doing what they were ordered to do over and over and over again, it ended their careers, it ended their health, it ended their relationships, and that even if 2 years, 3 years, 4 years later, somehow something happens and the justice system says, yes, you were correct, I've yet to see a situation where they actually felt like they had won. Again, the justice system doesn't necessarily provide justice. And even if you did go forward and have charges, and even if those charges were found successful, in my lived experience for the most part, the people still felt like they had lost. And so how are we capturing that? It isn't just how many cases go to civilian, it's also how many get carried forward, and then what are the results, but at what price? When we're in the military, it's very different. If I have outstanding legal issues, can I be moved? Can I go on my course? Can I get promoted? My entire career can come to a stop. And there still is sort of that scarlet A that you're doing something on the outside. You're kind of doing something disloyal because you're outside the family, out doing that civilian lawyer stuff, and nobody knows what's happening. And so it still does impact your relationship within the military family. There is an ostracization, there is social isolation. There's still such a price to be paid because it's not a good fit with still having a successful career and still feeling like you belong as part of a unit in the military while you still have outstanding legal cases that often
Thank you,
are
Dr.
years in
Breek.
the making.
Thank you. Mr. Savard Tremblay, you have up to 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you to the witnesses here today. I hope you know, as we often say, that we're here to study this bill, but we're here also to improve it if need be. So all of your suggestions are welcome. We'll see how to make things even better as we go. Dr. Breek, to start, are you hearing me? Yeah? Everything good? Yeah? I just wanted to make sure you could hear. You mentioned in an article that you published in the Hill Times last October, so it's quite recent, just a month ago, you say something about the Rangers and the cadets specifically. They had been set aside by the bill or forgotten. Why do you say that?
If I understood the question correctly, it was on the bill, how it is impacting the Rangers and the cadets. I will not claim to have expertise on the legal inclusion or not inclusion of them. I was using it mostly from the statements that were made by Lori Idolat on the NDP as part of the second speech on the documents that it was documented of those concerns from other from the NDP members. It would be a legal issue and of where that line is of who's covered and not covered. And so that's where I got that data from.
Peut-être que quelqu'un d'autre aurait la réponse dans ce cas-là.
Perhaps someone else would have the answer to that question?
Non?
Monsieur le Président,
Mr. Chair, if I may, I might offer a few written responses if that's okay. I'm not comfortable providing something right on the spot. Yes, certainly, that would be useful. That'd be very useful. No problem. With pleasure. So let's keep going. With that article you published, you said C11 is a solution for 2025, but is solution designed in 2015 and put forward in 2025. That's more or less what you were saying. So the context has deeply changed. You're saying that even if we go ahead, there needs to be more of a contribution. I think you just mentioned it in your own testimony of people who've experienced these types of things, and also federal funding that would be dedicated to give the civilian police the right resources to address more complex military cases. Often we hear there were two commissions, the people who've gone through this, we've consulted them abundantly. Now you're saying it's still not enough?
If I'm understanding the question correctly, it's we've already consulted a number of people. We've had all these reports. Is it not enough? And I'd like to just sort of comment, as someone who's been adjacent to all of those commissions and been involved, including as a witness to them as well, it appears sometimes that there's some cherry picking of what was said and how it was said. And certainly it's been my lived experience during that time period, especially when there was a very united concern that we needed the cases moved to civilian. At that point in time, what I keep hearing not included in that political discussion was we needed the cases moved to civilian because our rights were not the same at that time. And it was only until such time that they were equivalent, and then it would be better to be coming back. And again, the problem was duty to report. We had an obligation by law. We were potentially getting charged if we did not report, and yet we had no supports when we reported. We had no legal access when we reported. We had no victim rights when we supported, and we didn't have an SMRC when we reported. Under those situations, I think the community was fairly strong that we needed to move. And that was the conversations in my memory of what really helped force Deschamps and Arbor to feel so strongly on this. So my question, again, not knowing if it's possible, I personally would love to hear from those two amazing justices on, under present situation, where do they sit now? Because it's not the same military situation.
Ah, vous vouliez ajouter allez-y, vas-y.
Did you want to add something? Go ahead. Go ahead. If you'll allow me, I'll answer in English if that's okay. Yeah, no problem.
to dovetail on the topic of cherry picking, Justice Fish's recommendation number 68 is a temporary measure, and it reads as that. And the idea is that jurisdiction of those criminal code offenses of a sexual nature are removed from the military justice system until the Declaration of Victims' Rights is in place. I would submit that the Declaration of Victims' Rights was put in place, 2021? The report came out in 2021. So I would further submit that the military justice, with those important safeguards, was not given a chance to actually demonstrate how it can handle those criminal code offenses. Because, of course, as we know, history happened and a declaration was made in public and so on and so forth.
Bill Cease.
Gregor? You're on
Yes,
mute,
thank
sir.
you, Mr. Chair. Thank you, Mr. Chair. I want to reiterate that, and that Afton makes a very important point about recommendation number 68 and the follow-on in terms of the Victims' Rights Bill. The other thing that has to be pointed out is the SMSRC now has funding to have legal representation in court on a certain in-court applications and pretrial applications. That's not universally provided from province to province and territory to territory. These are things that we can have through the military justice system that would be consistent in all 13 other jurisdictions. That wasn't considered back in 2015, and it doesn't seem to be considered as a factor in putting this bill forward today. So I do think that there's been a lot of water under the bridge, and there's a huge reliance upon the fact that the civilian justice system is still far in advance on the military justice system in victim protection.
Okay, thank you, Mr. McGregor. Just far that was I let him go after the 6 minutes. Mr. Anderson, you have up to 5 minutes.
Thank you very much. My first question is for Colonel McGregor. You had mentioned triaging, which is the perfect word for it. I think triaging cases, and I ran into some statistics. This is almost a quarter of the cases that have been transferred to the civilian have been thrown out or not carried forward. Is this bill going to exacerbate that problem?
Well, who knows what's going to happen in the future? But as has been stated earlier, not all cases of sexual violence is considered a high degree of violent action. That's always a difficult way of characterizing it. But you're not going to get the kiss on the cheek in front of a provincial court judge or a superior court judge in any of the provinces or in the territories. We will, because there is a heightened problem with doing that within the military justice system and within the military milieu. So from a triage perspective, they don't have the time, they don't have the resources to put that ahead of other cases, what they're dealing with within their own jurisdictions. That is a real problem. Another real problem that has not been discussed is the triaging when you have witnesses from all across the country that are scattered all over the place. There is a cost factor to bringing them in to do the trial. And there were prosecutors and police that may be unwilling to proceed with certain cases of a more minor nature as a result of those concerns.
Very much. Ms. David, you had mentioned right now there's nothing in the bill that I see that requires communication between civil and military authorities. That to me is a problem prima facie right off the bat. And you suggested a liaison. Do you think a liaison is going to be sufficient for that, or should there be a requirement for reporting? And I'm going to reference an actual example from my writing, where an accuser and accused were both, because it was transferred to the civilian side, but because there was no communication back to the military, they were sent home on the same bus. And situations like that are bound to arise if there's no communication. So is a liaison sufficient, or should there be something in this bill, in your opinion?
Well, I on the sufficiency, I'm not sure. I wish I had a crystal ball so I could figure that out. But what I would suggest is that something in the bill would absolutely be necessary, some sort of provision. I think it would be a good first step as a liaison officer, some sort of kind of requirement for communication between the civilian authorities and the military authorities in the chain of command at the very least. And I think that would also, I would suggest that would also provide the accused and the accused chain of command the information we need, because as you heard, another one of my recommendations is some sort of provision that forbids statutory decision makers, but for potentially operationally requirement issues, from taking irreversible and permanent career decisions of the accused career. So I think that could potentially operationalize that other recommendation, in addition to making sure that epic fails that you just described don't happen.
Okay. Thank you very much. Dr. Breek, thank you very much for appearing today. I've got a young daughter, too, who's training to be a pilot, and I applaud your courage in that. You said that low-risk events should remain in the military. I think we've heard from Colonel McGregor that the reasons for that. But I'd like to, first of all, delve a little bit on the culture of the military, because that's very specific. And I think that there may not be the same understanding. You know, in a civilian, things are pretty straightforward. Can you talk a little bit about the culture in the military and how that may decrease reporting and cause issues when they arise?
Thank you for that question. There's a lot there to potentially unpack. Again, if we assume that the real problem we're here today to solve is to minimize any form of sexual misconduct in the military, knowing that we will never be 100% successful, then knowing that we have the right supports in place for when it does happen, and that we learn lessons from it so that it doesn't continue. When we look at the research that has been done by, especially in the U.S., it's been shown over and over and over again that these significant sexual misconduct-related issues don't ever sort of just pop up out of nowhere. They always start at the lower end, find that they are in a permissive environment where they either find the victim who doesn't push back when that first little thing happens, and or that if she does push back, or he, and they go to the chain of command, if they're blown off, not believed, nothing happens, that's a signal for them to keep going up the chain. So this is why those smaller events that may seem minimal, we know over and over again that is the key to helping prevent the larger sexual misconduct cases, by not allowing that permissive environment for bad behavior in the workplace. And so this is exactly the unwanted kiss, the unwanted touch, the unwanted harassment, makes it really the area to be focusing on to probably have the biggest impact on a positive culture and to minimize the sexual misconducts moving forward, which is why in a military culture as well, unlike sort of a normal job, I think of so many examples where I could not have done what the mission required without help of others. You're doing sea survival, you're in a poopy suit, you're trying to get into the lifeboat, you ain't getting on your own. And you are grateful that anyone can grab any part of your body that they can grab and get you onto the boat. And that kind of scenario is not uncommon in the military. Continue one step further, you're in the plane, there's turbulence. You're on the ship, that there's turbulence. People bump into each other, touch each other on a frequent basis that you don't see in a normal workspace. And we have to be able to trust each other, and we have to be able to understand when that 99 times when it's a normal touch that it just happened. But with that one time that it's not, we need a system in place where we can actually identify it and address it without suddenly being told, oh, no, that's now considered a sexual assault because he accidentally, groped a breast, even though he says he tripped and that it was nothing. Things are not black and white. We've got this gray area that the best place to be addressing that is still as a professional discipline in the military context.
Thank you, Dr. Breek.
This
Thank you.
takes that away from us.
Mr. Anderson, thank you. Chris Mallette, you have up to 5 minutes.
Thank you through you, Chair. I'm going to direct my question to Dr. Breek. In testimony before this panel, November 6th, Megan McKenzie made the point to spell out, and if I'm finding it correctly, Professor McKenzie said she would just reiterate that the idea of having a choice is somehow better for survivors is actually, I would say, inaccurate for most of the victims and survivors that I've spoken to. In the moments following an incident of sexual violence, it is very difficult for a victim to understand the consequences of that and the complexity of that choice. The default position for many survivors is to work within the military justice system, not because they think it's a better system, but because that's the system that they're in. It's the institution that they trust. Many survivors after that process wish that they had been given a different option and are not satisfied with the choice. We know that from the same research that she mentioned here, clarity for the victim, regaining trust in not only the criminal offenses within the military system. But did I take it to understand that you, however, believe that having that choice is fundamentally somehow better for the complainant in these cases?
Thank you for that question.
I don't mean to pit you against
Well, and I
another
think
witness.
it's a really important part on the importance of words and the importance of definitions of words, and to be really clear about what we're talking about and what we're not talking about, because that's where we get confused. Megan, of course, has written the book, Good Soldiers Don't Rape. So by definition, a lot of the people she will have talked to are, when we talk on that spectrum of what sexual misconduct could be, would be at a different spectrum. I would like to suggest the vast majority of the cases that actually meet the definition of sexual offenses are actually at the lower end. And so what kind of sexual offenses are we talking about? Again, because by the definition, it is any unwanted touching on a sexualized part of our body, it's a very, very low requirement that it is actually a sexual offense. And so I think it's important, again, when we look at this bill, there was 28 different sexual offenses. So I learned a whole pile I didn't even know existed. So we are clear here, we're not talking children, which again to me would be another entire conversation that is worth having for the issues around cadets. But assuming we're not talking cadets and children, assuming we're not talking animals, children, anything, and we're just sort of talking non-violent, non-injurious sexual events, to me there's only like 3 out of those 28 that fall into that category, which would be the low end of the sexual assaults, voyeurism at the low end, where it's just been opportunistic, there's no recordings, anything of that nature, and publication of intimate items. Those are 3 areas that even as a medical officer, we would see routinely variations of this on deployments. It's a very common areas that we get involved with how to address. That again, we need to be able to address those lower end ones versus talking the more significant cases that I think we all agree, those need to go forward. So it's that pushing ourselves to be comfortable in the gray zone instead of considering everything as black and white, if that's helpful.
And my next question then would be for Ms. David. David, what challenges do you foresee in coordinating evidence collection and handover then between military investigators and civilian authorities, and how can the bill be strengthened in your estimation to manage that?
If I'm being honest, I'm not entirely comfortable answering that question, only because I haven't looked into it or researched it, and the last thing I want to do is provide you with incorrect or inaccurate information. What I would suggest is perhaps Mr. McGregor would be a better person to answer that question.
McGregor, yeah. So I'll redirect that question then to Colonel McGregor, if I may.
Thank you, Mr. Chair. To the committee member, what has to happen is the evidence has to have proper continuity. The continuity is vital to make sure that it's not tainted, it's not lost, it's documented all the way through. So there's computer programs that deal with that. I know that the military police, the National Investigation Service have been working on that for years in terms of keeping all of that together. And then what would have to happen is that there would be probably a liaison officer in each and every province and each and every major city to deal with the NIS or the MPs as to from the NIS more than likely to a local prosecution office, but its continuity of evidence is vital, and it has to be strictly documented. Otherwise, you can lose cases right from the get-go.
Okay.
Yep, time's up. Thank you, Mr. Millett.
Thank you, Chair.
Monsieur Savard-Tremblay, you have 2.5 minutes.
Merci. Une des questions, bien sûr.
Thank you. One of the questions that's come up the most so far is having to do with the transferring of the appointment processes. for a good reason, you can't let the military system self-regulate, be both judge and jury. And I think that's what we were referring to when just Mr. Vance was saying that he was untouchable, essentially, because he controlled the process. The question is, now, by sending it to the governor and council, does it mean we're politicizing a process? Are we actually worsening the situation? Madame David, why don't we start with you?
Thing expecting different results. So what I see this as is trying something new. So I don't see it as an issue. I think it's a step in the right direction. I would again echo my earlier sentiment that if we're going to have the governor and council make appointments or designations, by the way, this goes beyond the ones in the bill, and I would suggest this includes all other appointments or designations, including but not limited to the chief military judge, that we include a limitation period. And there needs to be meaningful consequences to not respecting that limitation period. But it's a good start.
Justement, aussi, le projet de loi, il permet d'exclure.
In fact, the bill means that military judges can be excluded from summary hearings, but they still fall within the code. Is this a problem to you? Yes, it is a problem. And in fact, I wanted to address the question by Madame Gallant earlier. I strongly suggest maintaining the amendment where the military judges, the military justices at the unit level,
although it could be seen, I guess, as like a great equalizer, that no one is above that military justice at the unit level. We have to think about military judges. They preside over courts-martial. They have to be sufficiently independent and impartial to provide decisions free of apprehension. I'm just kind of citing the Valente decision, which is a landmark decision in terms of independence and impartiality of the military judiciary or of judges just period. So thinking about the potential undue influence where a judge could now be charged and punished by their non-judicial chain of command, who is a representative of the executive branch, that is an obvious and flagrant issue in my mind. And I would also suggest that the fact that military judges are subject to the Code of Service Discipline still, on that same kind of line of thinking, is still an issue. And I would provide, hopefully, some reassurance that if military judges are removed from the Code of Service Discipline, they're still subject to the criminal code, like Mr. McGregor mentioned earlier. There are different mechanisms to actually remove judges administratively within the judiciary as well. So it would be well covered from a professional regulation perspective as well as a criminal perspective. And contrary to what Justice Fish recommended, I don't think I would suggest that provided they're removed from jurisdiction of the Code of Service Discipline, they don't need to be relieved of their rank, because their rank would be perfunctory at that point.
Thank you. Thank you. Mr. Pazan, you have up to 5 minutes.
Thank you. And first of all, I want to thank all our witnesses for both your military service as well as your civilian service, all of you after you served or currently serving as a civilian, but as a reservist. I'd also ask that all of you provide your opening comments in writing to the clerk for circulation. You've all made recommendations and changes to the potential changes to the bill. I think we need to have those in writing to make sure we get that right. So my first, just to follow up, Ms. David, on what you're just saying, though. So you're in favor then of Clause 11, making sure that military judges are not, or they can't be fined, what does it say here, not charged with having committed a service infraction. So even if a military judge then goes and is abusing their position, knowing they can't, and using, essentially conduct unbecoming of an officer with some of the subordinates, and using language that may not be a criminal offense or even be on the verge of a sexual offense, but can't be. You don't believe that they should be disciplined for that?
I do agree that they should be disciplined for that, and what I would suggest is that there are mechanisms in place whereby they could still be disciplined for conduct that is unacceptable as a member of the judiciary. As a lawyer, I'm subject to I would suggest rigorous.
But they still wear the uniform.
they still wear the uniform. I would suggest that at that point, provided legally speaking they're not subject to the Code of Service Discipline, the uniform is, almost, perfunctory was the word that I used. So I would also suggest, because a military judge, and I would submit that judges should still have to have, especially in the military judiciary, at least 10 years of service. I think that that's an important requirement for a military judge. Them having a rank, I would suggest, is just respect to their career of being a soldier and a member of the Canadian Armed Forces. That being said, there are mechanisms in place to discipline judges within the existing framework outside of the Code of Service Discipline.
Colonel McGregor, you agree with that?
Well, respectfully, Mr. Chair, my view is that as long as they're wearing a uniform, they should be subject to the Code of Service Discipline. Infractions, I can see no, but service offenses, yes. And if you're going to wear the uniform, then you should be subject to the Code of Service Discipline, point final. And then we'll deal with the cases in a court martial, or if it goes to a civilian system, then it could deal with it that way. But I don't agree with the perfunctory nature of the uniform. When you wear that uniform and you have that rank, that means something.
Just want to get back to you, Colonel McGregor. You talked about everybody getting appointed now as order in council, so political appointments, but 7-year terms, but that they still should be subject to removal, not suspension. Should we be adding here, like other order in councils, you serve at pleasure of the government? So wouldn't we be able to clean up a lot of this if we just made it so even the JAG, for their 4-year appointment, serves at pleasure, as it's defined under the National Defense Act? Do you agree that they should serve at pleasure?
No, I don't think the DMP or the DDCS should be serving at pleasure. It should be in good behavior.
Okay. Dr. Breck, thank you again for being here. And you did talk about quite a bit how this has taken away a choice for the victims. So how do we fix this bill, which doesn't give that option? So how do we make sure that as everybody has said, this is no longer 2015. Madame Deschamps, and we should have Madame Arbour back committee here talking about their reports and how things have evolved and how certain mechanisms have been put in place. But how do we ensure victims are getting what they believe is in their best interests? And what happens if they go through the civilian system and, of course, it gets either thrown out because of the way evidence is presented or lack of knowledge of how military operates, as you clearly detailed. How do we get it back in where at least there can be some sort of discipline within the Canadian Armed Forces and some sort of justice for the victim?
Easy question. I think part of it always still comes back to prevention. That if we put as much time and energy into preventing the problems, we'd have less problems. And then the problems that we did have would be less severe. Again, when you understand military culture, by going into the civilian system, which often can take years, that is years of stress on that person that almost always impacts their performance in the workplace. It impacts their relationships in the workplace. And as soon as you start having chronic stress problems, you start usually manifesting them in some way, mentally or physically. And as soon as you get a medical problem, that can end your career. So again, I think as a physician, this is part of what I've seen over for 35 years, that even when somebody rightly goes forward, does exactly everything that was asked of them, and yet they lose their health and they lose their career as the result. So the system as it stands is not working, which is why I think, again, it's so important that we started catching data. It isn't just how long have people waited and what is the outcome. It is how did that impact their life? How did that impact their career? Again, there was a very important person that had started up It's Just 700 many years ago. And I remember always saying, what is the goal? What is the perfect situation? Because we're always still going to have problems. And her comment was, and I don't have a better answer, but when something bad happens, and you know that it was wrong, and you can name what it was, and you know what your options are, and you can choose what you want to do and how to do it. You want to wait till you're off deployment and around family to come forward. And then whether you report or whether you don't report, your career and your promotion continue either way. When we have those kind of stats, then we have a system that's working.
Thank you, Dr. Breek. Mr. Watchorn, you have up to 5 minutes.
Monsieur le Président, et merci à tous les témoins.
Thank you, Mr. Chair, and welcome to all the witnesses here today, and thank you for your service. I think it's important to say it, that we are all very proud to have you represent our country. I had an opportunity to discuss with Dr. Breek. I had a chat with her, and I really appreciated that conversation. I want to really highlight the excellent work you've done with our female armed services members. We're all here to discuss Bill C-11 and also mostly to build an environment of trust. That's what we want. We want people who are within the forces feel that they are in a trustworthy environment that is exempt from harassment of a sexual nature or otherwise. We want a good working environment, people to be well supported. I've already said it, and I said it in another committee. The example of the sexual courts that are being set up in Quebec is a good model. It indicates to us that sexual assault type offenses are distinct, are different from other offenses. You need specific expertise among the judiciary, that people need to be specialized. And I think the purpose of Bill C-11 is to try to bring the same expertise to the table here to defend our forces. We know there's no perfect justice system. The military justice system will never be perfect. The civilian side will never be perfect. But we're seeking a system, a model that works as much as possible. When you hear Justice Arbour say, and I'll say it in English because I've got the quote in English, I'd like your position on this.
Arbour dit,
Justice Arbour says, when it comes to choices, if we had the choice between military and non-military back in the day,
giving the choice to victims to choose the jurisdiction in which they find themselves puts them in an untenable position. If the case doesn't go their way, then they find themselves re-traumatized with the possible question, did I make the wrong choice here? That creates severe psychological distress to a victim. Now, on vous a entendu, Dr. Breek, dire que...
We heard you, Dr. Breek, say that the opposite is also possible. I'd like to hear your perspective. Give us a recommendation for this to work.
Is that
Yes,
to me?
give him a recommendation.
I might
for it to work.
David après.
And I think when we try and fit everything into one answer, when we keep trying to simplify things, that there's only one answer required to fix everything is part of the problem. All of this is complex, wicked problems that are going to need multi-pronged, multi-answers. I personally am very interested in the idea of these specialized crime units, specialized crimes, which is the way the U.S. has gone. Is it working better? Don't know. Again, stats looking forward, but it makes sense to me. Again, when we say about the choices of going backwards and forwards, again, I think it's really important of what are we actually talking about here? Because I cannot, again, as someone who's 35 years now in this environment, we all know when there's that one bad person whose touch is too long and it's just creepy and we don't want to be on a deployment and sharing a tent with him. We need to just be able to cut that in the bud. We need to be able to say there's something not right here and can we deal with it and not make it into the civilian police scene. And if we have a system that allows us to speak and be heard and deal with it, even if by definition it still is a sexual offense, there's this gray area. And we keep trying to make everything black and white. And in the military, it's not. We have this huge gray area that we need different options for dealing that gray area. And so, again, having specialized resources or a specialized MP session or a specialized civilian section, those are all really interesting things, which comes back to data And again, we've said now all civilian cases since 2021. So where's the data? There's 4 years of data. And again, not just data as a civilian military. What was the success from the perspective of the accused? And again, I'm all about supporting women, but I know a lot of men. And some of them have had their lives torn apart, and it has been a horrible, horrible experience for them. Like, we have to do better on both sides. They also need help and support. Their family needs help and support. I know many men that have been suicidal over accusations that they were 100% feeling innocent from, and yet they haven't been getting the same helps and supports either. We need to do better for both sides of how to address that gray area especially. So I am really fascinated to learn more about the Quebec system and how that works. That's an option to look at.
Thank you.
Sorry,
Time
I
up.
talked too long.
5 minutes.
Merci.
Mr. Kibble, you have 5 minutes.
Chair, and thank you to our panel for being here and contributing and for your service. And I really appreciate your comments that this requires being accompanied with cultural change, and I hope that everyone here hears that message. I certainly do. I'd like to start with Ms. David. You mentioned sunset clause is missing from C11. Could you expand on that for me, please, and explain?
Yes, absolutely. So a sunset clause would effectively, there are many ways to go about it, but ideally it would, one way you could do this is put an automatic expiry date for that specific amendment. I'm specifically talking about the removal of jurisdiction for these criminal code offenses of sexual nature from the military justice system, and then that provision would stop having effect, for example, unless positive action is taken by the legislature. So it forces the legislature to do the studies, review the data, etc., to see what the effect of this legislative amendment was. And so that's, this is one of my examples of meaningful consequences.
Thank you. And do you have some other examples where you would want to see that sunset clause applied, or perhaps you could either expand on that or submit written?
I can certainly noodle it a little longer and
Sure.
come back
No,
to
I
you
would
with
like
some
to-
written submissions.
Yeah, okay. Thank you very much, and I would certainly like to know more about that. Dr. Breek, based on your experience and your comments, we've discussed C11 taking away choice, and we've also discussed, although it's tough terms to use, but low, high levels of offenses, and as you've described, gray areas. Do you support do you support having choice between military and civilian systems at all these different levels, at low, high, and gray areas, or would you see some structure around that, say for low or gray or high?
I am the medical doctor, not the lawyer here. I must say I have learned a whole pile about law, having to read up about all of this. So it is my understanding, and I'll let my lawyer friends correct me if I'm wrong. For a lot of the sexual offenses, they are recognized as either like a class 1, class 2, class 3, and or a low, mid, high in fairly understandable differentiations. For me, everything I have been focusing on is strictly and solely at that low level. Not even the mid and the high, the low level. No violence, no weapons, no major injuries, just those very little gray areas that, touched my breast, you touched my butt as you walked by.
So would you want to
Those
see
low
choice there,
levels.
or?
Well, and I think right now, the way the bill is, there is no choice because you've made it such a high bar for me to report. I cannot imagine a scenario where anyone's going to report those to a civilian system for them. So we're not going to report those little ones, which means we know statistically the people doing that are going to feel empowered to continue on and on and on until we get into the mid and the highers, and that we're forced then and only then, preventably, to now have to report because they're at the higher level because there was nothing to stop them at the lower levels.
Thank you. And if do you feel that if victims had the choice that they could report it within the military system, then that they would then make those reports?
Again, when we're talking these lower level issues, certainly I can speak for myself as well. we just want it stopped, right? We just want it to go away. We want them to know we don't like it, we don't want it, it's not welcome. Sometimes there's mixed wires, especially when you're young and you're in your early 20s. Sometimes there's genuine mixed wires. You thought it was wanted, but when you've clearly said this isn't wanted, you just want it to stop. In a perfect world, maybe they even say sorry. But that's it. We don't want civilian cases. We don't want to be treating them as sexual predators.
At the low level, thank you. Do you agree, Ms. David, in terms of the low, medium, or high, that they should all have choice or be limited?
I would submit
from a legal
that
perspective?
from my perspective, I think they should all have a choice. For the reasons indicated by Colonel McGregor as well, considering both the safeguards and entitlements to the accused, but also the safeguards and entitlements to the victims now within the military justice system. I think that we should at least give it a chance to deal with all of the levels of sexual misconduct.
Thank you very much. And my next question is for Mr. McGregor. Could you please explain the differences in the process and standards for which military police versus civilian authorities collect their evidence, and would there be conflict or potential loss of evidence between the two systems?
I think what you'd have to do is talk to the provost marshal on that specific. Oh, sorry. Yeah, no, I'm on. I think you'd have to talk to the provost marshal, and I think the provost marshal would be talking about that directly. But I do want to say that in reference to the previous question and statement from Quebec, we established, while I was the director of military prosecutions, the DMP SMART, which is a sexual misconduct response team, and that was led by our Lieutenant Colonel Maureen Pecknold, a reserve prosecutor within my shop, and she has been acknowledged nationally for her level of expertise as a top-notch prosecutor out of Toronto on all high-level cases, including serious sexual assault cases, and she led our team. It's those types of things that we did within the military prosecution service that responds to what is being celebrated in Quebec. We did it. We had a small prosecution service, but we had high quality in being able to do that and respond.
Thank you, Mr. McGregor. Sheriff Marminato, you have up to 5 minutes, and I think we're going to be wrapping it up soon.
Thank you very much, Mr. Chair. And through you, I'd like to thank the witnesses for being with us today. I'm actually going to be sharing my time with my colleague, MP Idlaut, so I'll just make a brief statement, and then I'll turn it over to her because I think it's important that we have every voice at that table. Dr. Breek, you mentioned what the goal is, and I think we all agree what the goal is that we want this to stop. And despite having a duty to report, despite us repealing it, the question for me is always how many never came forward out of fear of reprisal, how many suffered in silence, how many left the Canadian Armed Forces forever traumatized, and to this day may not come forward. And so my hope is that with us bringing forward this legislation, those who have suffered can find some resolution, but also that we can stop this. So I want to thank you all for what you're doing, because as a mother of serving members, I think it's really important what you're doing. So I want to thank you. With that, I'll turn it over to my colleague.
Sherry, to my colleague, I know how important your voice is in this important committee, and I appreciate you sharing it with me. And thank you to the women veterans that may be in this room for showing your support, and especially to thank you both for appearing, and very specifically to Dr. Breek. I really hope that the committee takes your sixth comment in your submission very seriously. To you, I do want to ask specifically about victims and survivors. I see that in this bill, for example, that there's going to be a transfer of cases to civilian courts, and I think that we need to hear specifically what other resources besides funding will be needed for provinces and territories to make sure that the victims and survivors representation is adequate, to make sure that they get the justice that they deserve.
It's a big question. By definition, hopefully, they're still in uniform. So again, their health services are still the responsibility of health services. I personally am still someone that feels that it is our responsibility as the Uniformed Health Services to be doing as much as possible, still within the context of obviously, if it was a health services person that was the perpetrator, keeping the confidentiality and all the trust aside, but providing full supports, mental, psychological, spiritual. Again, I'm not personally highly religious, but I've always used the military chaplain system, and together as a team, as an interdisciplinary team, where we could have social workers, psychologists, physicians, chaplains helping and support in a more direct manner. Sometimes when we keep saying it's somebody else's job, then nothing happens and people fall through the cracks. I think, again, sexual misconduct has largely been dealt with as something outside of the healthcare system instead of something embraced as a public health issue, an occupational health issue. We haven't been leading the parade in helping and supporting our victims on this area. Again, I always am humbled when I look at especially Indigenous ways of the importance of holistically looking at people and making sure that they're cared for, including peer support, community support, and following some of the initiatives already from an Indigenous lens as well. I think all of the military would benefit from capturing that and bringing that into our world much more.
Thank you. Ladies and gentlemen, I'm going to suspend our meeting. Thank you to the witnesses for being here today and for providing some insight. To the members, we're going to be going into camera, an in-camera meeting, and it's an anonymous witness. So I'll also ask everyone except our members to remain in the room. If everyone can please to vacate and provide some privacy for this next meeting. Thank you. That includes the staff. Thank you. Meeting suspended.
Thank you.